Welcome to today's program titled Corporate and Planned Fiduciary Duty, Addressing COVID-19 Liability Risk. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box next to your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of today's webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn this over to Kathleen Cahill-Slott.
Hello, and welcome to Seyfarth's webinar on Corporate and Planned Fiduciary Duty, Addressing COVID-19 Liability Risk. My name is Kathleen Cahill-Slott, and I will be moderating the webinar. Joining me on the panel today are Tracy Davis, Ada Dolph, Candace Quinn, and Rhonda Prusak. All of our bios are attached at the end of the slides for your reference. We have a full agenda today, as you can see, so I'm going to hand it over to Tracy first, and if we have time, we will answer any questions at the end. Tracy, you have control of the slides. Take it away.
Thank you. Good afternoon. I'd like to thank you all for joining us today. I appreciate the opportunity to speak with you about directors' and officers' exercise of their fiduciary duties of care, loyalty, good faith that they all owe to their corporations as well as their respective shareholders. Right now, corporations are under unprecedented stress as a result of COVID-19. To give some context, some of those pressures corporate management is facing include just a few: financial distress and insolvency. As you well may imagine, directors are often under pressure to maintain healthy balance sheets. Here, under the stresses of COVID-19, they must repair balance sheets when incomes have plummeted and markets have been closed for months. So not only must the corporate fiduciary duty look to cut expenses, conserve corporate resources, and find ways to manage shareholder value, when facing insolvency, directors have a heightened duty to the corporate creditors, where they have an increased interest in the underlying value of the corporate assets. Another area of severe concern is managing cybersecurity and data privacy risks. Having shifted the workforce to a work-at-home plan, corporate fiduciaries must also take responsibility to see to it that the corporation's data and that of its customers is not jeopardized by any work-at-home arrangements. I will discuss this in greater detail later during my talk, but suffice it to say that cybersecurity and data privacy are major concerns. It cannot also go without mentioning the heightened risks associated with business interruption and continuity. Not only is shortage of supplies and disruption of corporate supply chains impacting corporations' ability to carry out its core function, ESG and other sustainability targets are also facing seismic upheaval in this time of social unrest. And then finally, we cannot leave out the corporate fiduciary's responsibility to manage its greatest asset, its workforce, and the employee benefit plans in dealing with the challenges of furloughing and terminating employees. These are undoubtedly unprecedented times and challenges that boards are presently facing and facing in real time. They are forced to address novel and pressing legal issues without much of a roadmap or a guide. Although these issues are novel and times are stressful, the legal framework remains the same. Boards would be well served by focusing on principles of good corporate governance. The fundamentals are making well-informed and well-documented and deliberate decisions, taking action in a thoughtful and precise way through a majority vote of disinterested directors, staying educated and informed of corporate policies and industry standards, and of course, seeking out the guidance and advice of experts. Let's take, for example, cybersecurity and data privacy and the heightened risk of theft, fraud, and hacking that has resulted from our greater dependence on technology to carry on our business. The same pre-COVID threats are present through the acts of the same bad actors, whether it's wire fraud, wire interceptions, email spoofing, email account stealing, leaked credentials, use of ransomware, hacking, phishing, the list goes on and on. But it only takes one bad actor to cause a breach. Corporations are well advised to handle the heightened risk of being targeted by a cyber attack or preventing a class action data privacy litigation by keeping information governance at the top of directors' minds. In meeting the duty of care and in making informed decisions, the board should always stay familiar with and routinely assess the effectiveness of the corporation's cybersecurity protection systems. They should and stay familiar with the corporation's response plan in the event of a cyber breach. They should also routinely assess whether all of the components of that response plan are in place and in effect. Also, corporations should know about the data collection, use, destruction, and other information governance practices that have been adopted by the corporation. Finally, all the preparation in the world is as only good as the training protocols that are in place to ensure that from the top down, cybersecurity policies and practices are in fact being implemented. I pull up the screen of recently adopted requirements and regulations to help corporations mitigate some of the risks that are associated with cybersecurity and data privacy. I strongly encourage that even those entities that are not regulated by the New York Department of Financial Services take a look at the cybersecurity guidelines as well as response plan guidelines that have been promulgated by the Department of Financial Services, because they are considered the trendsetter industry-wide on how to effectively create and implement a response plan. Also, the Cybersecurity and Infrastructure Security Agency under the Department of Homeland Security has promulgated best practices to avoid coronavirus-related phishing and other remote working risks. Finally, because there is no federal data privacy statute, the best that corporations can do is to look to these industry thought leaders, such as the Federal Trade Commission, for guidance and best practices on how to assess and suss out whether or not home network settings present an heightened risk. I also list FINRA for those who are regulated by FINRA's standards and guidelines, as well as for data privacy protection protocols, the international data protection authorities that issue regulations in connection with the GDPR. As a takeaway, I encourage each and every director, advisor to directors to be proactive in assessing whether or not their practices and procedures are being fully implemented, again, relying on experts, and of course, to stay current with industry standards and practices. Now I'm going to turn the conversation over to Candace Quinn, who is going to focus on the specifics of what kinds of data breach litigation exists in the ERISA space. Candace?
Thank you, Tracy. ERISA fiduciary breaches. In the U.S., retirement savings held in defined contribution plans, which includes 401k plans, have grown to over $6 trillion. Due to the significant amount of money held in retirement accounts, the theft of participant retirement plan confidential private information, including financial data, is a real target for identity theft and fraudulent transactions. There has been an increase in the ERISA class action lawsuits that are alleging fiduciary breaches involving cross-selling participant personal data. And ERISA, or the Employee Retirement Income Security Act, which is a federal statute governing retirement plans for private industry, is silent on the data protection in the form of electronic records. And there is no comprehensive federal regulatory provisions governing cybersecurity for retirement plans in the U.S. So recent ERISA litigation includes allegations of increased use of this confidential participant data by record keepers for cross-marketing without the participant's knowledge or approval. And this can include accessing the plan participant's contact information, financial data, investment preferences, and dates of retirement. Now, ERISA does not specifically address if participant data is a plan asset protected under ERISA. Although ERISA does not outline specific duties for protecting data, the Department of Labor, which is the enforcement agency for ERISA, has recognized the risks related to electronic communications of plan information in their regulations and directed plan administrators to take appropriate measures to protect the confidentiality of the personal information of the participants' accounts, to prevent unauthorized access. Also, the DOL, in some technical release, has found that the plan administrator is required to take the necessary measures to ensure that the electronic systems protect the confidentiality of all personal plan information. Not only the DOL has recognized the risks regarding transmitting participant plan information, but the ERISA Advisory Council proposed to the DOL guidance to help sponsors to assist with mitigating potential data breaches, including how to evaluate cyber risks for benefit plans, how to build an adaptive cybersecurity processes, and how to monitor and test to control access, as well as to address third-party risk management. Also, recently, Congress has asked the Government Accountability Office, the GAO, to examine cybersecurity of private retirement systems. Now, the GAO was asked to address a number of questions concerning cybersecurity. These involve cybersecurity for insurance, cybersecurity for bonds, and just the federal law regarding cybersecurity. A report is expected soon, which is anxiously looked for. Now, we know that monetary assets of participant accounts are plan assets, and a fiduciary must take steps to protect that from theft, and including theft from cyber breach. However, there's no clear ERISA regulations governing the protection of financial information in retirement plans. Now, whether a failure to protect retirement-related financial data is a fiduciary breach could depend on whether the financial data is considered a plan asset. It's been the DOL position that the assets of a plan generally are to be identified on the basis of ordinary notions of property rights. And this is based on a DOL advisory opinion from 1992. Now, there are several different tests that could be applied to determine whether plan data is a plan asset. The courts in earlier cases have reviewed whether the data has any value or whether the assets were viewed or treated as plan assets. But due to the focus of value of personal data in our current society, a recommended approach is definitely to take careful steps to protect it. Now, the ERISA class action lawsuits allege that there are breaches of fiduciary duties of loyalty and prudence for failing to safeguard confidential information. But who is an ERISA fiduciary? Well, a plan fiduciary is either a named fiduciary or a fiduciary through actions that result in the exercise of discretionary authority or control with respect to the management of a plan or its assets, or providing investment advice for compensation, or having discretionary authority or responsibility in the administration of a plan. Well, why is it important to know if you are a fiduciary? Because fiduciaries can have personal liability for plan losses. So what are some of the fiduciary duties? Well, fiduciaries are subject to the prudent expert standard of care, and they owe a duty of loyalty to plan participants. They must discharge their duties solely in the interest of the plan participants and beneficiaries for the exclusive purpose of providing those benefits to the participants and beneficiaries. Well, what has been the result of the litigation that we've seen in this area? Well, in recent ERISA class action settlements, sponsors agreed to prohibit the plan record keepers from soliciting current plan participants to cross-sell proprietary data and use that to market their products, unless the participant requests it and approves of its use. In another case, it was determined that the personal information of the plan participant is not an ERISA plan asset, as the personal information of the plan participants is not property the plan could sell or lease. Now, that was following the DOL's notion of property rights. Now, possible future litigation in this area will be addressed by Ada Dolph later in our presentation under Future Trends in ERISA Litigation. Already in 2020, a number of ERISA class actions in this area have continued. And the allegations are being made that the record keepers are using this participants' confidential data to aggressively market financial products and services without the participants' knowledge or approval. And more ERISA litigation is expected to continue. Now, the allegations against the record keepers are saying that they're using or selling the data to replace lost revenue from reductions in retirement plan fees. But what can fiduciaries do? There is no federal statute specifically addressing retirement plan cybersecurity obligations, and ERISA, which was enacted in 1974, is silent on the protection of electronic records. However, majority of states have statutes regarding privacy and cybersecurity, which Tracy mentioned, and while ERISA was intended to prevent multiple state law requirements from applying to the same plan, it's not clear that the lack of comprehensive privacy protection in ERISA would or would not prevent privacy and cybersecurity statutes from being preempted by ERISA. As discussed earlier, though, fiduciaries have strict duties of prudence and loyalty, and the ERISA class action litigation challenges continue. So what should a fiduciary do? Well, what fiduciaries should do is to take action steps to protect participant data and safeguard electronic access to those monetary assets of the plan, including being educated on the law, safeguarding confidential data, mitigating risk of data breaches, negotiating cybersecurity protection in the service provider's contract to protect the participant data and account balances. Review the third-party service provider's contracts, including the cybersecurity and data privacy provisions. Actually read the contract. Make sure there is a contract, and it does address data privacy and cybersecurity protection, and it's not just the marketing material. And ERISA counsel can provide guidance in this area, as well as on RFPs for third-party service providers. Fiduciaries should monitor the service providers carefully to check the steps they're taking to protect the data and determine if they are cross-marketing the participant's data without the consent or knowledge of the participant. And they should limit the record keeper's use of the data with regard to non-planned products and services. Fiduciaries need to be sure to understand the internal risks associated with transmitting data to service providers and be mindful of their ERISA fiduciary responsibilities. This concludes my presentation, and I'd like now to turn it over to Kathleen, who will address potential COVID-related ERISA litigation. Kathleen?
Thanks, Candace. So I'm going to spend the next 10 minutes talking to you about the potential COVID-related ERISA litigation and looking at an ESOP plan fiduciary's duties and how they can mitigate risk by properly exercising their fiduciary duty. So I see 4 areas of potential COVID-related risk litigation. And the first one is mistakes in offering continuing medical coverage for furloughed workers. What we saw is employers are frantically trying to figure out how to keep employees on their group health plans. But some may be actually promising continuing benefits to employees who aren't working, and the insurance policy that's underwriting that medical plan doesn't allow that. So everyone out there needs to, if you're an employer and you want to offer furloughed employees medical coverage during a furlough period, you have to review the applicable terms of your plan, and you also have to review the applicable terms of your insurance contract. Talk with your insurer. Find out, I'm going to furlough all these people. I'll find out whether or not I can still cover them. Because the last thing you want is a furloughed employee going and getting medical treatment and then suddenly stuck with a denied claim. No one wants that, so the best thing you can do is make sure you check out your policy. If you're self-insured, you have to check and find out, do I need to amend my plan? Does my plan allow me to cover furloughed workers? If it doesn't, make sure you amend your plan. I would also urge you to contact your stop-loss carrier and make sure that they are aware that you have this new class of covered employees that will be provided benefits during this time. So that is key for you to look at your plan document and see if you need to amend it. The last point on this is you have this duty of loyalty. We've been talking about prudence and loyalty. It's basically requiring you to communicate clearly to the furloughed employees of any continued premium obligation. So you have to, again, work with your insurance carrier to figure out the logistical challenges you may find with your employees that have a premium contribution, and give your employees a clear pathway so that they know how to submit their premiums during this time. The second area is with COBRA notices. And you're probably going to see increased litigation because you either failed to offer a COBRA notice because you've got a furloughed employee that you didn't check to see whether they could be offered coverage during this time. And lo and behold, they can't. They need to get that you didn't give them a COBRA notice for continuing coverage. So again, make sure whoever you're laying off or terminating, make sure they have their COBRA notice, because the last thing you want is those penalties for failure to provide COBRA notices. The other thing that I want to highlight here is that when you're providing COBRA, you want to look, or with providing continuing coverage for your furloughed employees, you want to make sure you wrap up and have all of the other coverages that are available, like life insurance. Again, check your plan and find out the menu of benefits that might be available to during the furloughed period or to the COBRA, to the terminated employees, and make sure they have enough information so they can convert their life insurance policy to a individual policy if they have that available under their plan. The third and fourth areas of potential COVID-related litigation is this if you're having a mass layoff or a mass furlough. Now, I mentioned this IRS rule of 20%. The IRS requires in companies that if you let go more than 20% of your staff, you have to ensure that each departing employee is fully invested in the retirement plan, their pension plan. So even if that employee hasn't worked at the company long enough to vest in the pension plan under normal eligibility rules, if you lay off more than 20% of your staff, each departing employee gets to be fully invested. So that's something to think about if you're thinking about laying off 20%. Now, I checked the registration list, and we've got a number of employers who have unionized workforce, and so they are likely contributing to a multi-employer pension plan. Now, one concern expressed by these employers is whether these temporary furloughs or long-term layoffs result in a complete or partial withdrawal liability. The short answer, we think, is no, that doesn't. But as with anything out there, the devil's in the details. So I really would urge you to, if you're in a unionized workforce, you're thinking about laying off and mass layoff. There's a link to the Seyfarth blog on labor relations. My colleagues have done an alert on this. They're experts on this area of law. And when we send the PDF, you can access that link directly. Again, I'm highlighting issues for you so that when you go back after this webinar, if this issue comes up and you're thinking you're a unionized employer, you just check this box to make sure you're covered and check with an expert. The last area of potential increased COVID-related risk litigation is with, of course, disability claims. It's not surprising. It's just another dialogue I want you to have with your short-term disability insurer or your long-term disability insurer, because you might get questions from employees who are at high risk for serious effects from COVID, immunocompromised employees, people with pre-existing conditions like asthma, heart. They may claim that they can't come to work because they can't risk getting sick. So you want to be able to make sure you check with your short-term and long-term disability insurers to find out what's the answer to that question. Are they covered? Is it a disability? These are questions we want to make sure you ask, especially during this time when everybody's kind of on a heightened level of anxiety. Speaking of anxiety, you might have medical personnel, and they might develop, unfortunately, due to the crisis, serious mental health conditions. I just want you to make sure you check with your policy, know how your TPA is administering these, you get mental health claims, and make sure that they're administering properly and covering your workforce if it's available for you with a short-term or long-term disability insurer. Okay, the last two slides I want to spend time talking about is potential ERISA litigation with ESOP and how you can mitigate that risk by properly exercising your fiduciary duty. I talk here about, and we've talked a lot about this unprecedented market volatility, and as an ESOP fiduciary, you have to worry about possible recession impacting your stock. The first thing you have to remember if you're an ESOP fiduciary is separate your settler job from wearing your settler hat versus your fiduciary hat. The settler, if you're working for a company and that settler functions are like reviewing company financials, finding out how you're going to design your plan, that's a separate function. Fiduciary duties come in when you're administering the plan. So if you have a job and you sit on, you have a job at your company, but you also sit on the ESOP plan fiduciary, make sure you're wearing the right hat, because as a fiduciary for this ESOP, you owe the duty of loyalty to the participants first and not the company. We talked about the duty of honesty, the duty of prudence. And these duties are so key because they are your defense if the plaintiff's bar is attempting to hold ESOP fiduciaries liable. They say that you may have breached your fiduciary duty when the price of the company's stock declines. By exercising your fiduciary duties and duties of honesty and prudence, you should be able to have a defense to this. The claims that these plaintiffs' bar allege is they say that the ESOP fiduciaries breached your duties because you allowed the plan participants to continue to invest in company stock, even though the company stock was potentially artificially inflated as a result of some undisclosed event, or it was too risky due to some special circumstances. So it wasn't really an investment option that should have been in the 401k account, in the employee's 401k account. And unfortunately, during COVID, company stock is particularly vulnerable in light of the downward movement in industries like retail, airline, hospitality. So your ESOP fiduciaries should work closely with their ERISA and security counsel to determine whether you need to communicate any information regarding your stock to participants during this time. And I'm trying to prime you with questions and for discussions for you to go back if you're an ESOP fiduciary, because here's some considerations. As a fiduciary of an ESOP, you should be aware of the economic impact and how it may affect your annual valuation. And you should discuss whether or not you're going to do a year-end evaluation or whether you're going to obtain an interim valuation now. So again, these are questions I want you to prime you for so that you have these discussions with your other fiduciaries when you meet on your investment committees. You should check the plan terms to see if there's any flexibility with your ESOP for responding to the market crisis. Could you do a delayed distribution? Could you have installment payments? Again, you're going to review and you want to make a plan regarding your communication obligations. You want to anticipate questions from your participants and have a plan for how you're going to accurately and timely respond to them if they have questions. You're also going to decide whether or not you should communicate anything else. This is working with your ERISA counsel and your security counsel on this. And when you're doing this, when you're having these ERISA fiduciary considerations with an ESOP as an ESOP fiduciary, you want to document everything, because you want to have that defense that you were prudent, you used objective criteria. So when you're doing this and evaluating these considerations, you want to decide if you're going to rely on experts. If so, who are they? Are they qualified? And what plan processes were followed, and what different options you considered, and why? And why did you follow the option you considered, and why did you reach the decision you did? Again, documenting is key, and as Ada will talk about next in our, she's going to talk about ERISA class action litigation in the COVID area. We want to make sure you are able to rely upon your prudent ERISA fiduciary considerations during this crisis, during this time, to help as a defense to any kind of lawsuit. Now I'm going to turn it over to Ada, who's going to talk about the class action trends. Ada, take it away.
Thanks, Kathleen. So I'll be talking about ERISA class action trends, as Kathleen noted. I'll be adding some more detail regarding things that you may do or consider doing now to try to mitigate the risk of these cases. So let's start by examining where we were last year, even before we ever heard the term coronavirus. So the ERISA class action trends last year, 2019 over 2018, and these statistics are derived from Seyfarth's class action report, show again that plaintiffs have been very successful in achieving class certification in these cases. And part of that is because of the uniformity with which plans issue disclosures and notices to participants, because of, for example, in the case of 401k plan litigation, the uniformity of the investment options that are offered to each participant. So for the most part, there's a lot of uniformity across the class, and that makes it very difficult to defeat class certification. So in 2019, we saw that trend continue. In 11 of 17 attempts by plaintiffs' counsel, classes were certified. That can be a very significant strategic point for those of you that have been involved in class action litigation, because it really sets in stone the exposure of the case. It can also be the start of very extensive discovery that will involve quite a bit of expense and battle of experts and things like that. So we do see in terms of settlements that they come very frequently on the heels of a class certification decision. So the next slide here is just to give you a sense of where we're seeing these class certification decisions made. Take a look at your most likely circuit. I will say there's some flexibility if you don't have a venue provision in your plan. That's something to consider if you don't already have that protection, which can put your cases sort of in closer proximity to you or in a jurisdiction that may have more favorable case law. There has to be some valid connection to that venue, but just something to consider. So here you can see the rate of class certifications across the country. The next slide here shows you how significant these settlements of these cases have been. So looking at 2019 statistics, you can see there ERISA settlements totaled over $376 million. And certainly those amounts dwarfed probably the ones that get the more headlines in terms of the employment discrimination class actions. So these cases are serious and something to pay attention to in terms of the exposure. A couple of the settlements I want to highlight just for their size. So the largest one in 2019 was $80 million, followed in second place by another for $75 million. these involved allegations with relatively larger class sizes. In the first instance of the use of company accounts as a vehicle to distribute ERISA plan life insurance benefits. The second one challenged the investments used in a stable value fund, which was proffered to participants as a very safe investment option. And the plaintiffs in that case challenged the underlying investments as not being sufficiently safe. So here we see, again, significant size settlements. So what do we see coming into 2020 in terms of the trends and where we expect to be? Have some of these cases sort of exacerbated by what we've seen going on with the COVID pandemic. So the first, and I'll kind of continue on what Kathleen was talking about, we do expect an increase in stock drop litigation. And there have been several cycles of this type of litigation. They do show up immediately during or after times of market volatility. So again, we expect here this to continue. Often what happens is you'll see a securities class action filed first, and then a companion ERISA class action comes close on the heels of that. In 2014, there was a Supreme Court decision that significantly tightened up the pleading standards for these cases. So for a period of time over the last few years, we have seen a decline in these cases, but we've also seen a very robust market performance. So we didn't have sort of the market volatility in terms of stock drops that usually precipitate these cases. So we expect these to continue. The claims are of the sort that Kathleen was talking about before. The company's in poor financial condition, poor long-term prospects, and should have taken some steps to limit or remove company stock as an investment option for participants. So one thing to note is even if company stock is built into your plan, ERISA has a higher sort of fiduciary duty that could require a fiduciary to override the terms of the plan. So it's not simply mechanically applying the plan. There's this extra fiduciary obligation to take a look at the market and what's happening with this investment option. And I'll give you some tips here that kind of apply to mitigating all ERISA class action risk. The first is, in this COVID environment, do not let COVID-19 disrupt your processes. So it has become very evident over the last 10 years in ERISA class action litigation that your process is much more important than the outcome. So you can have a poor outcome because, of course, many of us, although we try, are not going to be able to beat the market. But if you have a sound, prudent process to evaluate the investment options, to oversee the fees associated with your investment options, and then, of course, you document that, you will be in a much better position defending any ERISA class action. So don't let COVID interrupt those processes. Make sure you are still meeting regularly, that you're still doing the oversight that's required. And if anything, there's an enhanced obligation when we have market volatility that's deeply impacting participant balances to really have your committee engaged, meeting regularly, minutes, all kinds of documentation regarding that process to make sure you're protected going forward for what we do expect to see is an increase of ERISA class action litigation. So the next slide here, I want to talk about 401k fee litigation, which is another area which we've seen increasing over 2019. We expect it to continue into 2020. And we're also seeing a phenomenon where for a long time there was only a handful of firms that would bring these types of cases on the plaintiff side. We are seeing more and more sort of consumer class action firms get into this business, and they're also starting to target the smaller plans. So most of the large plans by now, over the last 10 years, have been sued in these cases. So now the plaintiff's bar is starting to go down to smaller plans and very closely examine their processes, the investments that were offered, and the fees associated with those. So you are not protected if you are in a smaller plan category, and you need to pay attention to these things. So the standard claims we're seeing here are the routine that the record-keeping fees paid were too high, that the investment management fees were too high. I will say one new trend we are starting to see, and that we do expect to have exacerbated by COVID-19, is target date funds. So there is no uniform one glide path for target date funds. So a target date 2021 retirement fund offered by one company may differ significantly in its underlying investments from that offered by another fund. So there's sort of easy pickings when you try to compare them against their peers. You will find a sort of wide range of performance year over year in this area. So what we're seeing is, along with the routine claims, we're seeing more focus on target date funds in these lawsuits. So as a committee, again, going to what you can do to mitigate risk, take a good look at your target date fund menu, see how it's performing against the fees that are being charged to participants. Other claims we're seeing show up in these class action lawsuits are challenging really more fundamental ways that the industry operates. So challenging and asserting that it's a breach of fiduciary duty to offer an investment option in a 401k plan that's affiliated with the record keeper. Also alleging that it's simply improper to offer an actively managed investment option as compared to a passive one. And certainly some of the theory behind actively managed is that it is better able to beat the market or to outperform a passively managed option in times of crisis like this. So to the extent that your actively managed investment options fail to do that, we expect that to be highlighted in these cases. There's also some allegations challenging fundamental ways that these fees are paid. So asserting that it's improper to have record-keeping fees paid as a percentage of assets. And that's a fairly routine, particularly for smaller plans, way of covering record-keeping fees and investment management fees. So we expect continued focus here. And then, as Candace touched on earlier, we're seeing some claims show up here focused on participant data and how it's shared with the record keeper and then used by the record keeper for other investment options to be offered to the participants. So something else to pay attention to. We are seeing these cases show up. So from a mitigating risk perspective here, make sure your committee understands the fees separately and as a whole. It's no longer enough to really look at return net of fees. You need to isolate the fees and understand if your record-keeping fees are matching up, and to do fairly regular benchmarking against other options that are available and against other record keepers. And that's the type of process, again, that you need to document very well to try to defend these claims effectively. So as I noted, we're seeing a lot more firms jump into these cases. We expect to see them increase. And we also are having sort of a procedural issue where many courts, given the complexity of the lawsuits, have been reluctant to dismiss them early in the case. So really the plaintiff's bar, and this has been referred to as sort of the newest cottage industry, is trying to get through that motion to dismiss gauntlet. And once they get through there, as an employer or a plan sponsor or a plan fiduciary, you're in a position of having to defend at high cost one of these cases. So that is another reason why we anticipate seeing an increase here. Just the trend is that the courts are less willing to pull the trigger on a dismissal earlier in the case. We saw mortality table litigation in 2019 increase. We expect that to continue. The short answer here is that the courts are working this out, and there is really no good answer. These claims involve that the plan allegedly uses unreasonable interest and mortality conversion factors, often based on 1971 mortality tables that were built into the plan, to convert a participant's single life annuity into another form of benefit, allegedly causing a reduction in benefits. So as I said, we're seeing some early decisions on these cases, but there's no clear guidance coming out of these cases yet or otherwise in the law for how to address this issue, which is very, very complex. So again, in terms of what the committee can do here, it's monitor these cases, be aware of whether you may have this exposure or not, and at this point, because there's no clear answer, it's continue to monitor and document that you're doing that. The next area that was touched on kind of tees off of what Kathleen was talking about in terms of the COBRA notices. With more furloughs and terminations, more employees are receiving COBRA notices. If those notices are deficient in any way, we expect to see an increase in this area of litigation. So it's already been going for some time, a couple of years, picking up speed. I would say fourth quarter 2019 and going into 2020, there's simply more opportunities to bring these cases. So these cases argue that because the COBRA notice is not the model notice, that it's deficient in several ways in terms of meeting the statutory and regulatory requirements for what information should be provided to an employee or a former employee. So in terms of mitigating this risk, as Kathleen had noted, take a look at the form that's being used by internally at your company or by your service provider. And if you're not using the model notice, take a look at it and make sure it's satisfying all the requirements, or engage counsel to do that. And in general, just a note regarding engaging counsel in the ERISA context, it's something that is recommended in terms of making sure you have privilege protecting when you're taking a look at exposure and liability, but always be mindful that there is the fiduciary exception to privilege that could apply. So these can be sort of sticky issues that you need to make sure you work very closely with counsel on if you want to make sure you maintain privilege. And now we'll turn it over to Rhonda.
Thanks so much, Ada. So what can organizations and companies do to protect themselves against the very expensive plan-related litigation that Ada just talked about? Well, one of the first things that they can do is to ensure that there are indemnification agreements available that are broad enough to cover the plan-related exposures and to cover the folks who are actually fiduciaries and administrators of the plan. Sometimes indemnification agreements don't necessarily cover plan-related issues, or they only cover directors and officers and not necessarily other employees who may have a fiduciary role. And indemnification is not always available, of course. So, for instance, in a bankruptcy situation, it may not be available, or again, if the indemnification agreement isn't broad enough. So what's the backstop? And the backstop is fiduciary liability insurance. It really is the next step and really the final step, I'd say, in providing protection. Now, at its core, a fiduciary liability policy is designed to protect against the personal liability imposed upon fiduciaries to restore losses to the plan caused by their breach of fiduciary duty. Candace touched on this earlier in the presentation. But so that's right, ERISA imposes personal liabilities. So even where a fiduciary makes an honest or inadvertent mistake in carrying out their duties with respect to the plan, they are expected to restore the loss caused to the plan by that breach of fiduciary duty. And as you can imagine, ERISA is complex, it's long, it's difficult to comply with perfectly, and mistakes are made all the time. So this is where fiduciary liability insurance comes in. Now, most insurance policies will have a basic insuring agreement that reads something like what I have up on the screen. Everybody's policies, every insurance carrier's policies differ a little bit. The wording might differ a little. This isn't an exact excerpt of a particular policy. But I have certain words bolded here. And any claim that comes in or any demand that comes in or that is made, in order to secure coverage under a policy, you would have to it would have to meet these defined terms under the policy, so loss, claim, insured, and wrongful act. So will there be coverage under a fiduciary liability policy for the types of claims or the types of litigation that have been discussed in this program? And again, does the claim or the demand or the alleged loss, does it meet the definition of loss in the policy, which includes damages, covered settlements, judgments, which would include pre- and post-judgment interest. Is the claim a claim as defined in the policy? Are the insureds folks and plans that are actually covered under the policy? Generally speaking, plans are typically covered on a blanket basis. They're not listed out. Insured persons is typically a broad definition that includes all directors, officers, and employees, and they're not generally specifically listed out. You want as broad coverage as possible. Plan sponsor should include all subsidiaries. And, of course, the wrongful act. There should be, in order to secure coverage under the policy or to trigger coverage under the policy, a wrongful act generally has to be alleged. Now, you should also take into consideration what's not covered under a fiduciary liability policy. I'm not going to cover every one of these, but these are insurance contracts, and there are typically exclusions in all these policies, and some of these are very typical. The few that I'll talk about to start with is the benefits exclusion, and this one causes a lot of confusion. Like, what do you mean that you're not covering benefits? Why are we buying the insurance? So just keep in mind what the purpose of the insurance is. It's to restore, it's to step into the shoes of the fiduciary and restore those losses to the plan caused by that breach of fiduciary duty, so that the individual will never have to pay a dollar out of pocket. The plan fiduciary can rest assured that they will never have to dig into their own assets to pay for a breach of fiduciary duty. Plan fiduciaries are not responsible for paying plan benefits, and that is not a personal obligation. So take, for example, where a company promises to pay a pension benefit of $500 a month, and then for whatever reason the company decides we're not going to pay $500, we're going to pay $250 a month. And then, of course, the plan participants sue for the additional $250 a month, and that claim is submitted to the insurance carrier. Well, that claim may trigger a defense obligation. It's a covered plan. They're making a demand for money and so forth. But the insurer will not cover that missing $250 a month. That's a benefit promised by the organization, and they have to live up to that. That's not a loss to a plan caused by a breach of fiduciary duty. The next item that I want to discuss is third parties. There is no coverage for third parties under the policy. Plans often hire a lot of third-party professionals. They hire record keepers and investment managers and investment advisors and actuaries. And all of these professionals carry their own professional liability, errors and omissions coverage, and that's where they should be looking for coverage. You would not want to drain a policy that's there to protect your directors, officers, and employees against their personal liability. You would not want to allow these third parties that carry their own insurance to drain the coverage that's available for your own directors, officers, and employees. Pretty much all these policies have what's called a conduct exclusion, and the conduct exclusion is essentially things like deliberate fraud, profiting from the plan in a way to which the plan fiduciary was not entitled, deliberate violation of laws and regulations. These exclusions don't come in at the allegation stage, and they typically really only apply after a final adjudication of a claim, after a final appeal. So defense obligations are triggered when these kinds of allegations are made. The other significant policy term or exclusion is the other insurance clause. And what this is about is when there is other insurance available that's intended to be primary to the fiduciary liability policy. So examples of those types of policies might be a cyber liability policy, or perhaps the company has a general liability policy that is supposed to, which typically doesn't cover breach of fiduciary duty claims, but it might cover those claims related to the day-to-day administration of a plan. So what does an insurance underwriter consider when they're contemplating deploying millions of dollars in insurance company limits and provide an insurance policy and provide breach of fiduciary duty coverage? Well, one of the things we consider would be the types of plans that the potential insured has, and are they the types of plans that are leading to more litigation? The size of the plan. The bigger the plan, generally the bigger the litigation, and the bigger the demands. But conversely, the smaller the plan and the smaller the organization, the more likely there are to be more mistakes made in the plan operations and in monitoring the performance of investments and staying on top of fees. We look at the claims history. If an insured has had a lot of claims in the past, well, are they going to have a lot of claims in the future? And most importantly, we look at those practices and processes that Ada was talking about. Do they have robust processes around the selection of investments? Do they monitor the performance of the investments and third-party service providers, especially plan record keepers? And do they document all that? Can they be defended in a claim? And then the question I always get is, well, how much insurance should we purchase? What's the right amount? And that's a tough one to answer, and there's really no hard and fast rule around that. So again, you want to consider the types of plans that you have. Do you have the type of plan that's more prone to litigation? What kind of activity is the plan or the organization that sponsors the plan undergoing right now? Are there going to be furloughs? Are there going to be layoffs related to COVID? You're likely to see litigation out of that. Are you undergoing transactions like mergers and spin-offs? Those transactions trigger litigation. Are you making COVID-related plan changes? Are you suspending your matching contribution to the 401k plan? Are you terminating a pension plan? Are you cutting off retiree medical benefits because they're expensive? All of those activities trigger claims, and you may want to consider buying more insurance. But of course, the best bet is to seek the advice of an insurance broker who's deeply experienced in placing fiduciary liability insurance. And with that, we'll end our presentation and take questions.
Thanks a lot, Rhonda. I'm going to announce right now the CLE code. It's S as in Sam, S as in Seyfarth, 0102. I want to thank Rhonda, Ada, and Candace and Tracy for their discussion. We've had a couple of questions come in. One question that, Rhonda, you might have answered in your presentation, but just in case, are fiduciaries open to be personally liable as well as the company or as a company employee? Can you talk about that and answer that?
I'm not quite sure, honestly, that I understand the question, but they're liable not as company employees, but as plan fiduciaries. And as I think Candace mentioned at the beginning, you're not necessarily a fiduciary based on your title, but it's a function of your action.
Mm-hmm.
If you make a decision that impacts or you have discretion over plan assets, then you're a fiduciary, regardless of whether your title is that. So it's certainly possible that your employer has asked you to take on that role, but you would be held personally liable or could be held personally liable and named in a suit for whatever decisions you make. So regardless of whether you've done that because your employer has asked you to do that, you are a plan fiduciary.
Right, and which is exactly why you get fiduciary insurance for these types of individuals.
That's right.
Fiduciary. That's right.
That's exactly right.
Right. Thank you, Rhonda. We also have a question that maybe Ada can address, is whether or not the issues about the lawsuits are going to, with respect to directing investing in stocks drops, are going to apply to an employee who makes their own investments and is sort of in a self-directed account. Ada, can you talk about that kind of situation?
Sure. And can you actually, I'm seeing right now, really quick, Kathleen, can you read the CLE code one more time?
Sure, absolutely. It's SS0102. Thanks, Ada. So if you're still on, Ada, we're talking about whether or not, if I have an employee in a self-directed investment account, whether or not I can be sued as a company for a breach of fiduciary duty for the investment losses in that employee's account.
So there is a defense under ERISA, the 404C defense. It was once viewed as very effective, but there are many points that must be satisfied for an employer a plan fiduciary to leverage that defense. And the other issue with it is that it's often very fact intensive. So there's only been a few times when you've been able to, as a plan fiduciary, leverage that defense early in the case to achieve a motion to dismiss. But I'd have to understand more about the plan at issue, but it's very hard under ERISA to absolve yourself of all fiduciary oversight and responsibility. There's typically something left with the plan in terms of what it must do to make sure participants have an appropriate menu, that the fees are appropriate, and some responsibility there. But there is a defense under ERISA that has been leveraged with success in the past.
Thank you, Ada. So unfortunately, now we've run out of time. If we're not able to answer any questions you might have after this presentation, if you want, our contact information as well as our emails are at the end of the slides. You can always contact one of the panelists with a question, and they'll reach out personally to you to answer your questions. Thank you for attending. We had a nice discussion regarding our fiduciary duties and COVID-19, and I hope everyone has a nice afternoon and stay safe out there. Thank you.